We at the Davis Law Group here handle many cases involving distracted driving. Oftentimes the most frequent cause of the distraction is a driver using their cell phone in some way, whether it's texting a message, reading a text message, or actually using their cell phone while operating a motor vehicle. The types of cases that we see where we believe there's evidence of distracted driving or using a cell phone while driving include motor vehicle collisions, bicycle accident collisions with motor vehicles, and also pedestrian accident cases involving motor vehicles. There's a common misperception among the public that all we need to do is order the cell phone records to prove that somebody was using a cell phone while driving their vehicle. Unfortunately, I wish it were that easy. Most cell phone technology right now, cell phones are constantly downloading data, whether you're using the cell phone or not. So when we get the records which shows data charges, that does not necessarily mean the person was actually using their cell phone while driving at the time, because the cell phone could be downloading information on its own. Typically, the way that we prove a cell phone or driving distraction case is circumstantially. The facts of the accident. Is it consistent with somebody being distracted as opposed to somebody actually watching the road and trying to avoid a hazard? We also rely heavily on eyewitness testimony. If we have an eyewitness that can say that the driver was actually on the phone at the time of the collision, then that is enormously helpful. Police officers can also play a role. Typically, most police officers now, when they respond to a scene, an accident scene, they will immediately retrieve the cell phone and look at the text message history or the cell phone usage history. However, an astute driver can delete the texting activity and or the cell phone activity so that when the police officer looks at the phone, it appears that no usage has actually occurred, when in fact it has. When we receive a case involving distracted driving, or one where we think the person who caused the accident was using a cell phone, one of the first things that we do is look for eyewitness testimony to see if anybody actually saw the distracted driving. Two, we will issue a subpoena for the person's cell phone records. Most cell phone service providers now will delete, for instance, text data after a certain period of time. Usually that period of time is very short, oftentimes no longer than 7 to 10 days from the date of the accident. So it's very important that the attorney act quickly to preserve that data if we can. And then we'll also talk to the police officer who responded to the scene.